and the Environment Agency and others are heard.
Mr Mould?
Well, I rise simply to mention that the court will have received, I think, two documents. Firstly, I think earlier this morning, a document in which I set out, after further reflection, the proposed revised wording of the declaration, and I've explained where that fits into our case in the paragraph that precedes the suggested revised wording.
Yes.
Unless there's any questions now, I won't say any more about that.
Clive, do you want
No.
No, nothing from us at this stage, thank you.
Thank you. Secondly, we have found found Form N463, the application for urgent consideration.
Oh yes.
You'll see that in section 1 the reasons for urgency are set out, and in section 2 the justification for the request for urgent consideration is also set out in the appropriate boxes.
Yeah.
And then the grounds for the application are set out in section 4, etc. So, again, I don't propose to say anything about it unless there's any questions.
No, not from us, I think, at this stage. Thank you very much, Mr Mould.
Thank you.
Yes, Mr Wise.
My lords, my lady, we were concerned with our response to the EA's appeal, and yesterday we looked at the essential contextual background. Another important preliminary issue to emphasise is what the judge recorded at paragraph 62 of his judgment. So if I can invite the court just to pull that up. At the top of that judgment, when he starts to deal with step 3, and you'll see he says there, in the beginning of the paragraph, finally, and as what I am calling step 3, Mr Mould QC submits that the court should accept on the evidence that the relevant individuals within the EA have sat down and designed measures which have been assessed will be effective in reducing the pollution to acceptable levels as advised and recommended by PHE. So that was the position before the court. The Environment Agency doesn't resile from that, and they make comment to similar effect in their skeleton argument in this case. And you see that at paragraph 38. Just invite the court to turn that off.
Yes.
In short, in this case, there's no doubt about what is required, the reduction of H2S emissions from the site to acceptable levels. That's paragraph 37, and then over at 38, onto 38. The appropriate, Roman 2, the appropriate way to assess progress was to establish, take PH advice and implement it. That is what the appellant made clear it had done and would continue to do so. So that then is the EA's position, and in those circumstances it's difficult to understand what the purpose of the appeal is if what they're saying is that they're doing this anyway. But it may be, and there's an indication of this in the Maloney Friends Skeleton argument, that the fear on the part of the Environment Agency is that this judgment sets a precedent that will be applicable in other cases. We see that from paragraph 62 of the appellant's skeleton. We say that that fear is unfounded. For reasons we'll come on to in a moment or two. The declaration in this case is clearly confined to its own facts. And in any event, it is hopefully very unlikely that facts such as this and situations such as this will arise again. And on that point, the court will have noted that from the judgment that there's been more complaints about emissions from this site than all the other operations that the Environment Agency are responsible for put together.
What I don't know, though, is what the number is, because if it's 4, not significant. If it's 504,
so over 40,000.
Over 40,000, that's a significant figure, yep.
Yes.
And that's in what span of time?
Can I come back to you?
Yes,
I
yes.
don't
I mean,
think
just
we've got that. We've got a graph that somewhere in the papers that.
yeah, but just broadly. I mean, obviously not
I
precisely.
think broadly, I think that would be from February, March, or thereabouts of this year.
Yeah.
Up to relatively recently.
Yeah.
And I think that figure's 45,000.
45,000.
45,000.
Right.
So very unlikely that a situation like this would arise again. Hopefully. But that submission was predicated on the declaration made in this case being related to the facts of this particular case rather than of general application. And then that goes to what appears to be the central issue in the appeal, and it was a point that my Lord Justice Lindblom drew out in exchanges yesterday from the first paragraph of the judge's judgment, and that is, what is the content of the positive operational duty? And that's, with respect, we would suggest that that's the central issue in this appeal, and whether the judge was correct in the way he approached it. About the content of the positive operational duty, we say this, that there are no clear terms of general application in which such a duty can be expressed. What the operational duty demands will depend on the particular facts of the case. Nevertheless, however, the following are integral. Firstly, the primary purpose of the duty is that it requires measures to be taken to protect life, which is a positive operational duty under Article 2, of course. And secondly, the measures that are required are those that are deemed to be reasonable by the court. Now we then turn to consider what is meant by measures that are deemed to be reasonable by the court. Reasonableness in this context, as I think Lord Dyson made clear in Rabone, is objectively reasonable as determined by the court. It's not Wednesbury reasonableness. And what the court deems to be reasonable, objectively reasonable, will encompass the particular circumstances of the case. That will include the nature of the risk to life, and will take into account the respect that should be accorded to the regulator. But we emphasise the content of the duty when determining what is reasonable must be focused on the fact that it is concerned with the most fundamental of the fundamental rights, that is, of course, the right to life. So there's therefore no template to be applied in all cases. And it's clear that the judge approached this issue in that way. That being said, then, the declaration in the present case can't be read across to other cases and other situations. And and if that's correct, this declaration has no precedential effect. It doesn't set a precedent. So
well, is that right, Mr. Wise? I mean, obviously it's right that the terms of the declaration arise from the facts of this case. Yes. But mightn't it be said that there's a principle involved, which is that the court's granted a declaration when it hasn't made a finding of unlawfulness? And might that not set a precedent?
Well, that with respect is a different question, my lady. We're concerned here with what the content of the duty is. And that was the focus of
well, I thought you were saying that this declaration couldn't set a precedent, and I was just exploring that.
Yes, because the content,
assertion,
as set out in the declaration, can't be read across into other circumstances. It will be fact specific. Now, in the present case, of course, the High Court was not saying that PHE recommendations are necessarily integral to the operational duty of the Environment Agency under Article 2. The judge was recognising that the Environment Agency had chosen the PHE recommendations as being those that which they would apply in these circumstances. And so in doing so, the judge correctly permitted the necessary latitude, and I think he uses the word latitude in his text, permitting the necessary latitude to the regulator. It was the EA that chose to accept the PA standards, not the judge that imposed them.
The problem with the declaration is it doesn't say they have chosen the standards set by the PHE, and if they stick to those standards, they'll be all right. Because it says those are the standards, and if the Environment Agency decided to change its mind, or the standards changed, or there was a better regulator, or they decided that there were just such difficulties at the site that a longer period was needed, it doesn't allow for that. And isn't there a difference between the Environment Agency saying, for the moment, we're going with PHE, and the court saying, you've decided that today, and you must hereafter and for all times do
Yes,
that.
I was going to come to deal with that, but I'll deal with it now.
Okay.
Now your Lordship raises it. It's obviously a matter of concern to the court and also of the Environment Agency. The possibility that the PHE recommendations may change, or there be a...
Or the circumstances
or the
may change. You
or
just
the
can't do
change.
it by the 1st of January 2022 with the best word in the world. And it may take until the 1st of February 2022. I mean, say there was a COVID outbreak, and again, and nobody could take stuff to the site or something, or the people just couldn't sit in the office and process what it is. This is a very, very prescriptive declaration.
Yes, on that point about it being very prescriptive, on looking at it at that high level, it is necessarily incorrectly prescriptive because of the nature of the right involved, because of the right to life. But the more specific point your Lordship raises is whether things may change, whether PHE or otherwise. And what we say about that is this, that any declaration may be invalidated by subsequent events. If, for example, a court makes a declaration of the legal obligations, and those legal obligations change, for example, by a decision of a higher court or the introduction of secondary legislation, it plainly wouldn't be binding. For example, to use the Bell case, looking, for example, at the Bell case, the court, if the court made a declaration as to what was required for a child to consent to a particular type of medical treatment. Now, the law on consent may subsequently change, for example, by the introduction of statutory guidance to medical professionals. Perfectly feasible, and very often, of course, Parliament responds to declarations of that sort, or orders of the court more generally. If that's the case, and the legal situation changes, then the declaration will be no longer binding.
But what is the Environment Agency to do in those circumstances? I've got the order in front of me. What, as it were, room for manoeuvre does it have in either of the circumstances contemplated by my Lord, i.e. the recommendations are modified or revoked, or circumstances on the ground change?
It would make clear to those affected that it doesn't consider that the declaration remains binding, because
You can't do that. One party can't say we're going to ignore the court. We've gone through the High Court, we've gone through the Court of Appeal, and they're useless. We're going to do our own thing.
But what the party can do, my Lord, we can just go to the other side of the coin. If the Environment Agency said that, then an affected party would have a choice. As your Lordship pointed out yesterday, this declaration is only binding as between Matthew and the Environment Agency. So don't just contemplate that scenario. Scenario firstly, that it was the Environment Agency telling Matthew that it wasn't any longer binding because, for example, the PHE guidance had changed. Matthew would then have a choice as to try to enforce the declaration in some way, or take any further action. And what would happen inevitably the court would consider the change of circumstances. And if there was a good change, if Matthew sought to enforce that declaration, just the same as if a declaration had been made in Bell, as
we did make one, yes.
The claimant in that case, I forget her name now. Forget the name now. But Kira Bell, sorry, yes, that's correct. Sought to enforce it. The court wouldn't have allowed that application to proceed, given what the Court of Appeal had said, because it's been overturned.
A declaration is an order of the court, and this is a public body.
Yes.
And in the system that we live under, public bodies and individuals must comply with orders of the court.
Yes.
They can't turn around and say, well, we think things have changed. We think it isn't reasonable to have 8 people working on this at the moment because we've got another landfill site and it's blown up and we're going to put 4 and it's going to slow it down.
Yes.
They can't do that, and it would be wrong of them to ignore a court order. In terms of enforcement, the only way in which you can actually enforce a declaration is by an application for an order sequestering assets. It's impossible, really, to imagine that Matthew would do that. He's not concerned with that. He's concerned about his health.
What he would do is...
But in reality, if a court has declared they must do something, a public body can't just say, we've taken a different view now, we've gone through lengthy court hearings, but we know better.
But that's that I suspect is what the judge had in mind when he refused my application to...
Yes, because he wanted to be able to enforce it.
Yes, absolutely. Your Lordship will understand why. But the judge resisted that proposal and said that that Matthew would have to issue a fresh claim.
Yeah.
Well, if Matthew issued a fresh claim, which came before the court, and there was good reason why the declaration had been superseded for some reason, then the court would say so.
It would refuse that claim.
Yes.
They've got the declaration.
Yeah.
Yes.
There's no means of enforcing or policing this.
No. But that's the nature of declarations, my lord. That is in the nature of declarations. As we know, declarations are made in all sorts of circumstances. It is a flexible remedy, as we all know. And circumstances may well change in any of those cases. It's fanciful to suggest that if there's a significant change of circumstances, not a de minimis change.
But the question is, who decides that there's been a significant change of circumstances? Matthew, the Environment Agency, or some other judge? And how?
Well, if there's enforcement action or if there's fresh proceedings, then obviously it would be the court that made that.
The court isn't dealing with the declaration; it's dealing with the new proceedings.
Yes, I know, but the declaration is predicated. The new proceedings are predicated on a declaration that's been superseded.
The declaration is, on the face of it, a declaration because the terms of the order of the rubric it is declared that. But the substance of the declaration is in mandatory terms.
Yes.
Whether that makes it a mandatory order or not, perhaps, is an academic question. But the declaration is in such terms as to require certain things to be done.
Absolutely.
So that's the context in which my Lord's question arises here. Because this is in effect a mandatory order.
Yes, we understand that, of course.
Yes.
And it was for these reasons that we were concerned not to set out a mandatory order, as your Lordship seen as the way as the case progressed. The view that we took before the judge was that a breach was sufficient, and then it would be a matter for the public body to take whatever action was deemed to be appropriate to remedy that breach.
Often happens.
Which is the traditional way of approaching this situation. So the question arises. I mean, it could be thought that the judge went further than we asked in this respect.
Well, I think the Environment Agency says squarely that he did.
Yes.
Go further.
Yes. Well, it could be. Yeah, that's what we meant by it. It could be.
That he went further than you had asked him
Yes.
to go.
So the question was then, was the judge entitled to go that far? Miller and Friend's submission was that the judge went too far, I think was the way putting that encapsulates the point very neatly. Was the judge entitled to go that far? Well, we see from his reasoning why he felt it was necessary to do so. Just bear with me one moment. In paragraph 64, towards the end of that paragraph, he says, I have made clear that I am not satisfied on the evidence that the Etin addresses legal duties in the way that it must, but there is an obvious and pressing public interest imperative that it must do so as a matter of urgency.
Well, it doesn't follow from that they've got to be told how to exercise their regulatory discretion.
No, but that's obviously, it was obviously in the judge's mind that the issues that were before him were of such importance and such profundity that the only way to ensure that Matthew's rights were effectively protected. I'm just looking for the passage where he said that it affords effective protection for Matthew. Just bear with me one moment. Should have noted that he does say he did recognise the environment. This is paragraph 67 towards the bottom of page 52.
Right. Is it 33 you're looking at, really, at the end? It matters if public health is going to be protected, especially for Matthew.
Yes, well, that's one point, but I think it goes a little
further than that.
But it's to similar effect, my lord. It's
yeah.
a very dense judgment. I don't have.
I mean, the judge clearly had Matthew right at the forefront of his mind, as this court does, because we do the legal arguments, but you've got a 5-year-old here.
Yes. Yes.
With health problems.
Absolutely. Yeah. And his view, in the exercise of his discretion, was that it was appropriate to make a mandate. Sorry. Slip of the tongue. A declaration in the terms that he did, very much related to the facts of the case. One can see the potential difficulties that may arise, but one then has to balance those potential difficulties with the benefits of the order that he made. If the benefits were that it was practical, it was to provide a practical relief to this child, which would have a real effect on his life. And bearing in mind, of course, the evidence was that this child's got a window of around 3 years, I think it is, to get his lung health back into such a situation that he can remedy the possibility of COPD and the subsequent shortening of life. So there's an obvious urgency in this matter. The judge, taking all those matters into account, decided that this was so urgent that this was an appropriate declaration to make in this case. Now, the court is obviously right that gives rise to potential problems. That's obvious, and that was what we recognised at the outset by not approaching it in that way. But then the fundamental question for this court was that an error of law on the part of the judge? It might not have been an approach that any individual judge other judge might have taken, or indeed this court. But that's not the point. The point is whether he was wrong in law, whether he is entitled to make that declaration, whether we like it, whether other people like it or not. And in these extreme circumstances, albeit that it wasn't the declaration that we sought, that's irrelevant, as we know. We say that he was entitled to make it. So I think that I was addressing there your lordship's point, my lord. Lord Justice Lewis, about the possibility of change and what the consequences of that would be. But if I can just return to the point that I was on just before we went down that route. We'd been considering what the content of the positive operational duty was. A comment was made from the bench, again I think by Lord Justice Lewis, that what the judge has effectively done here was to have legislated for what the Environment Agency had to do. And that was, and we take that point on board. It's obviously a serious point, and it's not the role of the court to legislate, obviously. But on analysis, he hasn't legislated at all, and that flows from what we say about the content of the operational duty. If what he'd said in this case was confined to its own facts, that's not legislation that would have an application.
By legislation, I meant he's fixed the legal standards. He's not said,
yes,
these are the standards you are going to follow, and if you do that, it'll be fine. He has said something further than that. He has said, these are the standards you must meet, and in the second case, by a certain date. That's what I mean by
absolutely, but that's the necessary consequence of a binding declaration in our submission, my lord, and not a matter of principle as to why he shouldn't make a declaration. Sorry, I'd understood your lordship meaning.
No, he hasn't said for every landfill site they must do this.
No.
He said for this one, but what he has done, on one reading of this, is fix the standards, and in one case the date.
Applicable in this case,
Yeah.
yes. But there's no reason in principle why a judge can't make a declaration in a human rights case as to what standards are applicable in particular circumstances.
If those are the only legal standards that could possibly be applied, yes.
Yes, but he does build in that latitude within the declaration itself, using the words in the regulatory judgment, in the agency's regulatory judgment.
Yeah, but that simply relates to the design of a scheme that will comply with what he declares the agency's legal duty to be. They must implement the advice.
Yes.
They
Well,
could have
what
a
he said,
different
but in
level
the
of
judge's defence
PPPs,
on that.
and they couldn't change the date.
Sorry, my lord.
They couldn't change the level of the one PPB.
No.
They couldn't change the date
No.
by which they had to achieve it.
But one then has to go back to the context in which the judge made it, and the evidence that he had before him. He'd been told by the Environment Agency that this is what they were going to do.
Yes.
He said that they were going to
The
implement.
question is, would that be lawful? And you don't disagree with that. If they did it, it would be lawful.
Absolutely.
The question is that the only thing they can do? And if they do anything else, or if they do it on a slightly different time scale, that means there is a breach. That is the question.
Well, with respect, my lord, no, the question is whether the judge fell into error in making the declaration that he did do on composite, all sorts of other potential alternatives. But on the evidence that the judge had, that the Environment Agency were relying on, had chosen to rely on these particular Public Health England guideline levels, and had committed to implementing them within the timescale that Public Health England had set out, were integral to the guidelines, because the 1 year is integral to the guideline which the PHE adopted, but it's by circuitous route. That was what PHE were recommending. But in those circumstances, he was merely recording what the Environment Agency had committed themselves to. It's difficult
But he wasn't recording it. He wasn't saying this is what they've said they'll do. He was saying this is what they must do.
Yes. Well, your ladyship's right. He goes further than just recording what they say they're going to do. He says that they must do. But he says that we would say with respect for good reason, because the context of Matthew was such that there was a threat to his life, and urgent action was required to ensure that his life wasn't foreshortened further than absolutely necessary, or shortened even further than had already been the case. It may well be, it was difficult to predict the consequences of the COPD and the amount of time that his life would be foreshortened. But when one considers the life of a child and his prospects being curtailed in the way that the evidence very clearly put out, I mean, we have to recall that the judge made a finding, having heard evidence from the relevant specialist, that his life was being shortened because of the current level of emissions. Now, it's difficult to imagine circumstances which would which would better justify a declaration in the mandatory terms, if I can put it carefully, such as this. We're not here concerned with whether a supermarket can have planning permission on a greenfield site or anything like that. We're concerned with the most profound issues that this court has to grapple with.
But if
And the
he's
judge had a
right
difficult task. Sorry, Milady.
But if he's right in principle, this principle would apply to a range of different public law cases.
One could imagine hypothetical situations where a risk to life arises, Milady. So, of course we can. But what we can't do is measure the correctness of this declaration by other hypothetical examples. There may be, we've stressed how extreme and how profound this case is. Similarly extreme and profound cases may arise. One obviously hopes not. But we're certainly not aware of anything that begins to touch on the circumstances of this case. And so the judge said he had to step up to the mark, I think was the way he put it. It was the phrase I was asking for. It's somewhere buried deep in the...
50, I think.
It doesn't matter where it's...
No, he certainly does say that.
The end of paragraph 50. The inexorable logic of these human rights...
Sorry, my lord, which paragraph are you on?
50 at the end is that public authorities and courts must step up, in inverted commas.
That's right, yes. So that was what I got in mind. So the judge was grappling with a very difficult issue, with frankly very little precedent to go on. This is the first time that we're aware of that an issue such as this has come before these courts. We've looked at some cases where positive operational duty has been considered by the European Court, but they're very different on the facts as we know. So the judge had a difficult task in determining what the duty required in this case and what the appropriate way of enforcing that duty is. So we'd say that he was very anxious, of course, to ensure that, as one would expect, he was very anxious to ensure that Matthew's rights were given practical effect. That, of course, is the whole purpose of the Human Rights Act being incorporated into the domestic legislation. So if you're going to have practical effect, then the court deemed, Mr Justice Fordham deemed, that this was the appropriate way of dealing with it. So if one steps back then and say, well, there's difficulties inherent in the approach that the judge took, but what else could he have done? Well, he could have just declared a breach and let the court get on with it, the Environment Agency get on with it, as we've said. But as you said, he said that one wouldn't do. That wasn't good enough.
Are you?
But if you want,
sorry to interrupt, Mr. Wines. Are you submitting that the judge did find a breach?
Well, it's very difficult because the language isn't entirely clear.
Right.
Milady. But then he distinctly says in the post draft judgment paragraphs that we've got at the end of the judgment.
68 is the clearest. In the middle.
But you did it with costs.
Yes. But nevertheless found that we were justified in regarding Matthew as the successful party.
I mean, taking the date that you said, the 4th of July, or the date of the hearing, the 18th of August, or indeed the date of the judgment, which paragraphs do you say establish a breach as at either of those dates of Article 2 and Article 8? Because you say in your grounds, firstly, he has found a current breach, and by current, I've understood you to mean current at the time that the application was made,
Yeah.
or possibly at the time of the hearing.
Well, he says, I forget which paragraph it is now off the top of my head, but he says that the EA has yet to meet its legal obligations.
Well, that's 64. I'm not satisfied on the evidence that the EA has yet addressed.
Yes.
68 connects itself to 64 explicitly. If you look at the foot of page 135, he's recording your submissions there, I think, on costs.
Yes, he's declined to make...
But first that's Mr Wise, Queen's Counsel, wanted a finding that the EA is in present breach of its obligations. And then he says, a finding which I have declined to make, see paragraph 64 above. And that connects, I think, to the sentence that begins, having granted that declaratory relief, I accept that it's not necessary nor appropriate for this court to say that there is a current breach by the EA.
Yes.
I've made it clear that I'm not satisfied on the evidence that the EA has yet addressed its legal duties in the way that it must.
Yes.
So, to make sense of those two paragraphs together, where clearly there's a connection between them in the judge's mind, are you saying that despite what he says in paragraph 68, and in the light of what he says at paragraph 64, he is finding a current or present breach?
What I'm saying is, at 64, it's ambiguous when he says the EA has not yet addressed its legal duties in the way that it must. Well, if it hasn't addressed the legal duties in the way that it must, the implication of that is that there's an error.
You've got to remember the context. This hearing is on the 18th of August. It was only the 5th of August that the PHE fourth summary with the findings about the EPA came out.
Yes.
And the criticism that the judge makes is that there's nothing in the paperwork to show that they tied what they were doing to the 5th of August PHE advice. So when he talks about yet, reading it in context, is that genuinely a finding that they haven't been doing anything that they should have been doing so far, or is it, in context and looking at the wording of the declaration, really tied to what is to happen next?
To remove ourselves from the present circumstances just for a moment, and actually to pick up something you said in passing a moment or two ago, is this like a situation in which a local planning authority determining an application for planning permission hasn't yet had the opportunity to convene its planning committee to consider the application? There is a concern on the part of local residents that a supermarket is going to be granted planning permission on a greenfield site.
Yes.
For all sorts of wrong reasons.
Yeah.
But the judge says, well, look, they haven't got to committee stage yet. They say they're going to determine it in accordance with the policies of the plan and the NPPF and so forth. They're not yet. Well, I appreciate this is deliberately taking the situation as remote as it could be on your submission from the present circumstances, to make sense of the ambiguity that you're now saying, or you are saying, is present in paragraph 64. Just to remove ourselves, if you like, from the present context, to see what the judge is actually saying.
But the context that your lordship raised there, the greenfield site development, if the law required a process of decision making and consideration before a final decision was made, then there's obviously no breach of law at an intervening stage. It's not quite what the judge is saying here, though. What he's saying is that they haven't addressed their legal duties in the way that
yet addressed their legal duties. And the question is, what does it mean by legal duties? He didn't say they have failed consistently and this child has been exposed to Article 8 nuisance for the period up to July. It doesn't say, and couldn't have said, that on the 4th of July there'd been a failure to apply the EPA.
But
it's all future.
He doesn't. But that's the point why we've got the cross appeal, Frank.
Yeah.
I'm going to come to that in due course.
Well, your cross appeal is the premise of your cross appeal is that there wasn't a
absolutely
breach, and that may be perfectly fair enough. I mean,
well, he certainly didn't make a declaration that there was a breach.
No, just understand what you're actually saying, though, and do it by reference to dates and the two articles. Are you saying that the judge A did or B should have found that as at the 4th of July there was a breach of Article 8 and or a breach of Article 2? Should have, not that he did.
No.
Right.
At the time of the issue of the claim form, I think, is the...
Or the claim form, whichever you want, yes.
Yeah. It's in July.
Was the claim form issued on the same date as the application for urgent consideration?
Yeah, 15th of July.
I assume so.
Yeah, I think so, yeah. It doesn't say date filed, but it looks as if it is.
Yeah, okay.
Yes, I'm sure it would have been.
So that means all the actions that have been taken, or all the failures to take action, up to, say, the 15th of July, did not involve any legal wrongdoing according to the judge.
Yeah. And that's the point we pick up in...
There wouldn't have been, for example, damages if that had been just and appropriate, because nothing illegal, according to the judge on this analysis, had occurred as at the 15th of July.
Just to make absolutely clear, my lord,
Yeah.
just in case there's any confusion about it, my client has, or my client's mother, I should say, has specifically disavowed that there's any claim for damages in this.
I'm just trying to find a way of testing it. The mother, this mother wants to look after her child.
Yes.
She's a good mother, and that's what she's worried about.
Yes.
She sees Matthew day in, day out. So when I say damages, I'm trying to find a way of pinning things down, because we're talking about covenant breach and so on, and I'm trying every which way I can to avoid any misunderstanding. And the way I'm doing it is by saying, well, look at particular dates. On the 15th of July, did the judge say the authority had already failed to do things, or was already doing things it shouldn't do, and there was an illegal action or an illegal failure to act? And to test it further, I'm saying, and if the mother had wanted damages, but she doesn't, she's a mother, she wants her child to be well, would she have been able to get damages? And the answer would be, I think you're telling me, no, because the judge had not found, although he should have found, that the authority was acting illegally at any point up until the 15th of July.
Yes,
that's right.
Sorry, I want you to just give that some thought, my lord. Yes, that must be correct.
And your claim then is that he should have found that by the 15th of July, or certainly by the 18th of August, Matthew's Article 8 rights,
yes,
the nuisance,
yes,
and his Article 2 rights, the risk to life,
yes,
had been established.
Yes.
And it wasn't just a question of you must do more over the next little while.
Yes.
You should have done it already.
Yes.
Put
Absolutely.
bluntly, Matthew shouldn't be where he is. He shouldn't have to wait another 6 months.
The operational duty is to stop the risk for life, not to.
But it's to take reasonable steps. Actually, and the question
Yes,
is, what date did it fail to take the reasonable steps?
Sorry,
Yeah.
but that was shorthand. But your lordship takes the point. It's to be preemptive, to ensure that life's protected, rather than to be acting after the event.
I mean, in a sense, can one say the judge took the view that this was, as it were, a preemptive claim? I mean, he didn't use the language of prematurity, but he was, I think, on a fair reading of paragraph 64, well, to use his language, not satisfied that the EA has yet addressed its legal duties in the way that it must. He was looking forward to the possibility that they might not, is what I think you're saying.
But he'd already found, of course, that's in the context of having already found a real and immediate risk to the life of this child.
Yeah, but the remedy isn't for that. The remedy arises out of the failure by this body to exercise its powers in a way which would avoid that. You can't get a remedy until you show, as you have shown, that Matthew's life expectancy is at risk.
Yes.
That's the starting point.
Yes.
The mother's done that. She's shown her child's life expectancy is at risk because of the landfill site. The next question, and what we're talking about, is by what date should it have taken action legally? That's the question here.
Oh, one could pin dates of a number of dates, as your lordship's posited both yesterday and this morning. But the question for the judge was there a breach at the time before? At that time before?
What I've written down in my note is the judge did not find that there was a breach as at July 2021.
Or
your
August,
submission is
or August 21 at the time
or August 21.
Of judgment.
And your submission is that, so that's what he found, that he did not find as at July 2021 or August 2021 that the authority was in breach, that is, it was acting incompatibly. And your submission is that the judge was wrong because he should have found that the environmental authority had failed to take steps by the 15th of July, or at least by mid-August 2020, which it was legally required to take.
Yes.
That's what your case is.
Yes.
2021.
2021, yes.
Yeah.
That's it.
That's the cross appeal,
Yeah.
my lord. If you just bear with me one moment, I'm not avoiding the question, but if I can just sequentially deal with the EA's appeal first before and explain why we're saying what your lordship's just set out. Now, we were concerned a few moments ago with the terms of the declaration, and my learned friend has sent a proposed alternative form of declaration, which the judge could have made. As I understand it, the EA's position is he shouldn't have made a declaration at all. I'm not quite sure whether it is a proposed declaration. But it's instructive to consider what the Environment Agency say was the limits to which the judge could have gone. If we look at the proposed revised declaration, in exercising its regulatory powers and determining practical measures for purposes, etc., it said that the Environment Agency must act on the recommendations of Public Health England stated in the fourth PHE risk assessment for as long as those recommendations remain current. The last clause there, that as long as they remain current, I think we've dealt with that can be superseded. But it's the phrase "must act on" that is the problematic one, because what does "must act on" actually mean? At least it must be conceded, even by the EA, that the declaration made by the judge had the benefit of certainty. But "must act on" doesn't provide certainty to anybody. What does it mean? Does it mean must have regard to, must consider? If it's must use its best endeavours, and that immediately brings its own difficulties, because number one, there's not, as you say, it doesn't have the necessary clarity. Number two, it doesn't give the certainty that this fundamental right requires. But also, it's impossible to objectively measure. What would Matthew and his family do if nothing changed? The EA had said, well, we've had regard to it. We're doing this, that, and the other, but and things are no better, and the risk to the child's life continued. What would he do? The only thing that he could do, of course, would go to court and say, well, they haven't properly had regard to, or they haven't acted on in substance, and it would end up essentially a Wednesbury challenge. Now, a Wednesbury challenge is self-evidently inappropriate as a way of enforcing a fundamental right such as the right to life. And I'm reminded about the inadequacy of Wednesbury review in cases where important statutory rights are at stake by the judgment of Lord Brown Wilson in the Tandy case that the court may remember, House of Lords case from, I think it was 1998. Now I'm hoping, and I think Melinda French Jr. has got copies of the judgment. It's
Now, is that the case about need? What needs?
no, that was the Barry case, I think, related, but it was related. It was all around the same time, and there was a debate. This was the educational duties.
Yeah.
And Lord Brown Wilkinson then considered the, I think it was the Care Act, I can't remember whichever it was. Was it Barry? I think it was Barry. Your lady might have in there.
Thank you.
Going back a year or two now, this is a 1998 case, so pre-HRA, the principle remains the same. This was a case concerning whether there was an absolute duty on a local educational authority to provide special educational needs for a child. The educational authority said that due to budget constraints that it couldn't provide the amount of educational support that it hitherto done. The court found that it couldn't take its resources into account and that it was an absolute duty. So if I can turn to the last page of Lord Brown Wilkinson's speech, at page 749 of the report. Sorry, your ladyship's right, and I was wrong. The Barry case preceded this, as we see from against the letter.
Yeah, so that was the one that was all about what needs and necessary needs.
It was a very live issue at the time,
Yeah.
as we recall. So if we pick it up at C, a similar argument was put forward in the Barry case, apparently on the ground that the complainant could control the failure of a local authority to carry out its statutory duty by showing that it was acting in a way which was Wednesbury unreasonable in failing to allocate the necessary resources. But with respect, this is a very doubtful form of protection. Once the reasonableness of the actions of a local authority depend upon its decisions as to how to apply scarce financial resources, the local authority decision becomes extremely difficult to review. The court cannot second guess the local authority in the way in which it spends its limited resources. See, for example, Cambridge Ex Parte B. Parliament has chosen to impose a statutory duty as opposed to a power requiring the local authority to do certain things. In my judgment, the court should be slow to downgrade such duties into what are in effect mere discretions over which the court should have very little real control. Parliament wishes to reduce public expenditure on meeting the needs of sick children, then it is up to Parliament to so provide. It's not for the courts to adjust the order of priorities between the statutory duties and the statutory discretions. Now, with respect, that's an important principle and correct, set out by Lord Brown Wilkinson. And if this obligation on the Environment Agency in this case was reduced to what would in effect be a best endeavours duty, doing their best, as per the terms of this proposed declaration, that's the difficulty that we fall into. This is even more stark in the present case than it was in Tandy, of course, because in Tandy it was education of a disabled child. In this case, we're concerned with the life of a disabled child. And so that sort of light touch declaration simply, we say, wouldn't be adequate to protect the statutory right of my client. There was some consideration, moving on to a separate topic, there was some consideration yesterday as to whether the judge had correctly interpreted the Fadieva case. If I may address the court briefly on that. We say that we didn't misunderstand Fadieva, and in any event,
it makes no difference to his overall analysis. As the court recalls, there was particular focus on paragraph 133 of Fadeeva, which the judge records in his judgment at paragraph 60. But whilst the facts of Fadeeva are obviously very different to those in the present case, what's important is the general approach of the Strasbourg Court in that case. And when one looks at the passage as a whole, as I see my Lord Justice Lewis is doing, what the court is concerned with there is that the state body acts with due diligence, I think is the phrase that he uses at paragraph 128. It's in the court's jurisdiction to assess whether the government approached the problem with due diligence and gave consideration to all the competing interests. In this respect, the court reiterates that the onus is on the state to justify using detailed and rigorous data a situation in which certain individuals bear a heavy burden on behalf of...
You said 28. Are you in 28 of the judgment? In fact?
Sorry, no, Fadeeva, my lord.
Yes, I'm in 28. Did you say...
1 to 8.
1 to 8, sorry.
Sorry.
As well, sorry.
I'm not sure.
The age will come to you one day, Mr. Walleys. 1 to 8.
May well have done, my lord. Did your lordship have that 1 to 8?
Got it now, yeah, I've got it. I finally got it. Yeah. My apologies.
There's the heading, the alleged failure
Yeah.
to regulate private industries, which starts at 124 on the preceding page. And one has to read all that passage before one gets to the concluding paragraphs at 133 and 134. And it's important, an important plank in the argument of the Strasbourg Court is what we find at paragraph 128, which is hardly surprising in the context that you would that a state body would be expected to act with due diligence and give consideration to all the relevant competing interests. And it's for that reason, your lordship recalls, that the judge below said that our alternative analysis on the common law has no traction because the common law obligations are written in effectively to the conventional obligations. The argument could have been the other way around, but nevertheless, the statutory duty, and that's the way the court dealt with it. And so that so what does that due diligence require? Does that due diligence require this the state to have done and to show that they've done? And paragraph 133, we see what he says about that. Now, if we go to the judgment, see what the judge pulls out from that as being relevant to his analysis of the principles to be applied. He draws out the sentence that's involved in the italicized towards the bottom of the page. There's no information that the state designed or applied effective measures which would take into account the interests of the local population affected by the pollution and which would be capable of reducing the industrial pollution to acceptable levels. And he extrapolates that, that he goes on to say that that's a clear encapsulation of what is sufficient and what's unnecessary for the Environment Agency to do in the present case. And it's difficult to see why that is controversial. If the positive operational duty is in play, then the relevant state body, regulator, must show the court that it has designed and applied effective measures which would take into account the interests of the local population, affected by the population, and which would be capable of reducing the industrial pollution to acceptable levels.
That seems to be a wholly uncontroversial statement in our submission. And the judge wasn't wrong to rely upon it in his analysis in this case. Now, the question arose during exchanges yesterday with respect to the words sufficiency and necessary, and what the consequence of that is. We will say that that's a semantic argument that doesn't affect the overall analysis. What, in effect, the judge is saying is that in order for a plan to be sufficient to discharge the operational duty to protect life, it is necessary for the authorities to design and apply measures capable of reducing pollution to acceptable levels. And that's a perfectly logical and sensible approach for the judge to adopt. And to use the language that I think Lord Justice Lewis used during one of the exchanges yesterday, there needs to be a plan which encapsulates what is required. You also put it in very short term, and that's all. And that's all it's saying. So there's nothing there in the reliance on that short passage that undermines the integrity of this judgment, or shows that the judge has approached, as a matter of principle, the content of the positive operational duty wrongly.
Do you accept a difference in principle between the need to have a plan on the one hand, and on the other, the need for the plan to be as follows? In other words, prescribed by the court. Is there a real distinction between those two concepts?
Sorry, I'm just trying to...
Well, to have a plan... Well, no, I'm probably not putting it very well. The need to have a plan is one thing, perhaps. The need to have a plan which is as follows, prescribed by the court, is another.
The plan must have a purpose. The first point I'd make is the plan must have a purpose. The plan must have as its objective to reduce the emissions to acceptable levels. And I don't think
that describes what the plan
is.
What the object of the plan is.
The intervention of the court comes if of course there isn't a plan that does that.
Yeah, but you've got to look at the context. In February, March, they started the monitoring. They've had the complaints. They've got the monitoring. They don't get the final advice, which makes the second recommendation for the first time, until the 5th of August.
Yeah.
And then you've got the hearing on the 18th of
Yes.
August. And the question is it a breach of Article 8 in this, Article 2 in this regard, if between the 5th of August and the 18th of August they haven't got a plan
Two points
to address
that,
the PHE advice that came 13 days earlier?
Two points to that, my lord. The first point is that they'd had 3 risk assessments prior to the...
That's why I confined it to the second recommendation in the EPA level.
Yes, you did.
And Article 2.
Which the judge acknowledges is brand new.
Oh, when it was. There's no doubt about that. That was the first point that we were making in context. But the second point is the point that I made at the outset of this morning's hearing. And that's what the EA, Mr Mould on behalf of the EA submitted to the judge. And I'll take your lordship back to it. It's paragraph 62. The first sentence. Mr Mould submits that the court should accept on the evidence that the relevant authorities within the EA have sat down and designed measures which they have assessed will be effective in reducing the pollution to acceptable levels and as advised and recommended by the PHE. Their case was never that they hadn't had time to do it. That this is something that has only just arrived, and they're going to roll the sleeves up and address it over the next week or so, or whatever. They say they've done it. Now, there's no disagreement with that. Certainly no appeal against that. And if that's the case, then the EA aren't entitled to come to this court and say we haven't had time They say that's what they've done. So the timing issue, with respect, my lord, goes out of the window. It may well have been a point that they, well, it's a point that they couldn't take because of what they say that they'd done.
The way I read the judgment, it may be my fault, is that they were saying, look, we're doing all of these things. Look at the Sarah Dennis action plan. I couldn't find that in the evidence as it happens, but they were looking at the Sarah Dennis action plan, and that'll be fine. And the judge's point was, well, you haven't got anything in the documents, when you look at 62 and 63, that ties the action plan or any of the other documents to the second recommendation, the PhD advice. And the answer is, they couldn't have done that on the date of the evidence, because the evidence was due on the 6th, and the plan only came on the 5th, or the advice came on the 5th.
Yes, it subsequently became apparent that the plan became, I mean, it wasn't clear before the judge at the time of the hearing when the plan came. But all Sarah Dennis says in her statement, if you recall, I forget the paragraph now, but all she says is she's going to review the situation. What she doesn't say, and there's no evidence from the EA to this effect, nobody from the EA says that they are going to review the plan to ensure that measures are put in place to implement the recommendations of Public Health England.
Well, what I don't know yet is, on the Article 8 point, on the WHO guidelines, has the judge found that they hadn't addressed the off-site odours, or they weren't seeking to address the off-site odours? That's one thing. And then, am I right in thinking that the reason why the judge thought that the EA submissions on Article 2 and the second recommendation were wrong, because there was nothing in the documentation before the court that showed that the PHE one...
Yes, they weren't able to demonstrate that there was a plan. And your lordship sees the way that he...
No, they weren't able to demonstrate a plan. The cross-referred to the 5th of August PHE advice, as I understand it. Not that there wasn't any plan. There wasn't a plan that was cross-referred to the P... That's why they call it a flight plan.
Yeah, what... Can I just remind myself of what...
So, two questions, really. Sorry to keep asking you questions. But one, is there any assessment of the adequacy of the arrangements for the odour point, the WHO guidelines?
No.
So there's no assessment of the adequacy of the measures for Article 8?
No.
And then the question is...
And that's the substance of the cross-appeal.
Yes.
Yeah.
And then the next question is, have I misread, or what does the judge say? Is he saying that there's a breach of Article 2, is he saying that it's the absence of documentation before the court specifically related to the second recommendation of PHE?
Yes, it seems to be. I was just looking up the passage where he deals with that. Can I invite the court to turn up paragraph 63? So, we're concerned here with what he describes as Mr Mole's step 3, which, I wonder if we've got it in shorthand, what these steps are. But it's the final stage of the obligation. But he goes on to say, I'm not satisfied on the evidence that officials within the EA have done what compliance with the applicable legal duties require. My reasons are as follows. Rather than read it out, can I just invite your lordship to read, I think it's about a third of the way down to the point 3 that he makes there, the no reference anywhere.
Yeah. There's no document, and there's no reference to the witness statement.
Yeah.
I have a slight difficulty. How can you criticise them for not having a reference in the documents that had to be prepared by by 12 p.m. on the 6th of August, that they don't refer to something quite detailed that they got on the 5th of August?
Well, to be fair to the judge, I think that he was saying by the time that they got to court, I think he must mean there. Well, he does mean that there was nothing before the court at that time.
The evidence had to be put in by 12 p.m.
Well,
on the
it did,
6th of
but,
August. They couldn't have put in any more.
No, but the hearing started on the 18th of August. There was no endeavour to put one in. And indeed, what we know from subsequent events, the plan was finally produced, I think somewhere late October, I think it was, in the end.
Is at the hearing that nobody knew.
Oh, and I'm reminded by my junior that there was a lot of evidence submitted to the court after the deadline and set in the direction was hearing. And
Yeah, a lot of it would be helpful to know precisely what came after and what. I mean, it's not enough just to say there was lots. I mean,
I can't.
You've looked at the directions. The directions tell me 12 p.m. on the 6th.
Yes.
And he seems to be criticising Miss Dennis, who's the one who's looking at the implementation plan. And hers was the 6th.
Can I look at that over the adjournment?
Yeah.
Like, I forget exactly what statements were put in at a later date, but there certainly was evidence put in later. And there was the opportunity to do so and apply to do so. But the judge's rationale there is predicated on the submission on behalf of the EA that they've done it.
No, that they've done it in substance. Different. And I don't know whether or not they have done it in substance for Article 8 odour.
Well, no. What the judge says, that somebody needs to say, I have assessed that these measures will achieve below 1 part per billion average from January 2022.
Yes, that's the second recommendation. That's the Article 2.
Yeah, oh absolutely, yes.
And trying to separate them out. It's not enough to be general. This child is complaining Article 2 and Article 8.
Yes.
Article 2, the first hint of the 1ppb thing, being the absolute standard, comes on the 5th of August. And that's what these paragraphs appear to deal with. There doesn't appear to be anything saying they failed to take relevant steps or are taking relevant steps in relation to the odour, because they've got all that other evidence about capping and containment and so on. So we've got to focus. And as far as one can see, the paragraphs you've shown don't address Article 8 and the WHO. It's looking at Article 2 and the lack of a reference to the 5th of August PHE, and they all seem to have been required to be filed by the 6th of August PHE.
Yeah. But that then was the rationale for the judge's approach there.
So are you submitting, Mr. Wise, that the judge found a breach of the Article 2 duty because the Environment Agency hadn't taken all of this on board?
Well, the judge
assessed it.
The judge found that the Environment Agency had yet to do what it was required to do under its procedural obligation under Article 2.
So when does that, if that is a breach, when does it crystallise? Had the Environment Agency breached their duty at the date of the issue of the claim form?
Well, we say that, and this is our cross appeal, milady. We say that duty crystallised long before with respect to the 5 parts per billion.
That's your case, but we're looking at what the judge said.
Just focus on what the judge decided. If you're right and the judge found that this was a breach, when was that breach committed?
Well, the judge says that at the time of the hearing before him, they hadn't complied with their obligation.
No, not yet addressed its legal duties in the way that it must.
Yes.
And from what date? So it's the 18th is the answer, is it?
Well, it must be. We've not yet must be linked to the...
So you're not submitting that there was a breach of this duty at the date when the claim form was issued, are you?
No.
Right.
But save that we get, to avoid confusion, we're concerned here with the correctness, or whether there was an error of law on the part of the judge to have made the declaration that he did, not our cross appeal.
Yeah.
No. I'm just exploring what the consequences of one of your analysis of the judge's judgment is. Thank you.
So we say that the timing issue didn't arise before the judge because he just simply hadn't got the evidence that they had complied with the procedural obligation.
Well, he's got lots of evidence about Article 8 and the noise. Where does he deal with Article 8? Because there's two.
He doesn't. That's the point of our cross appeal, my lord. He just doesn't. He seems to have. It's obviously a very detailed judgment, very learned judgment, and in lots of ways a very good judgment. But our criticism of the judgment, is that there's a blind spot.
So on Article 8, are you saying we must decide whether or not there was a breach as at the 18th of August, or is that today's date? Or are you saying we must remit it to another judge to decide?
We deal with that in our skeleton argument.
Okay.
It's a matter for the court. We say that.
What are you inviting us to do?
Find that the judge was wrong not to have found a breach of Article 8.
And what happens next?
And make that order reconstitute yourself as a high court and make that order.
So
you're asking us to find a breach?
Yes.
Can we just find the relevant passage in your skeleton argument to be clear about that? Please.
I think it's the very last paragraph, my lord, if I recall correctly.
So we need to read into paragraph 64 of your skeleton argument that this, that so far as Article 8 is concerned, we would need to actually formally to reconstitute ourselves as the administrative court.
Yes.
Because this is not by way of interfering with the order below, it is to substitute an order of our own for, or to put an order of our own in place where there is none.
And absolutely. And if we're right in our analysis, the judge, the error of law that we identify is that the judge was wrong not to have found a breach. It necessarily follows that the court must have concluded that there was a breach, and it would be surprising that would have to go back to the High Court then to for further reconsideration. That's a matter for the court, of course, but the modern approach to dealing with situations such as this by the Court of Appeal is just to make the order rather than remit it back to the matter back to the.
We've got the findings, you say, for Article 2. We know what he found about Article 2.
Yes.
But so is that we don't know what he thinks at all about Article 8.
No, but but the point on Article 8 is that if you adopt, just bear with me one moment, see if I can encapsulate the point. What we say is that the logical reasoning that led the judge to the declaration, the underlying reasoning with which we agree, which required action to implement the PHE's long-term guidance of 1 part per billion by the beginning of January, if that compels a finding of a current breach of the EA's operational duties with respect to its failure to take action in accordance with PHE's recommendation that the half-hour 5 part per billion limit be achieved as early as possible.
Sorry, where are you reading?
This is a note that I tried to encapsulate the submission. I perhaps haven't done it as clearly as I might have done. What the judge has done with respect to the 1 part per billion, the Environmental Protection Agency of the United States guidance, 1 part per million daily average over the long term. He looked at that prospectively and said that in order to comply with that regulation, that recommendation, there must be an operational plan that shows how that's going to be achieved. But of course, the 5 part per billion recommendation wasn't time limited in that sense. And
the recommendations had come earlier. They started with the first one, recommendation, then strong recommendation.
That's absolutely.
And the question you'd have to ask is whether or not the implementation plan would address that.
Yes. Yeah.
And that had gone in, and Mrs. Dennis was looking at that, and we don't know what the judge thought about that.
No, got a blind spot. It seems to have had hesitate to be overly critical, but he seems to have had a blind spot in concentrating on the 1 part per billion long-term guidelines. He's overlooked the point that my lord just alighted on, and he was wrong to do that, and that was an error of law. But that was always, of course, integral to our case.
Well, he made a single declaration, all-encompassing declaration.
He did.
And you're contending that the analysis underpinning that decision was flawed.
With respect to the 5 parts per billion
Yes.
guidance, which wasn't time limited, of course, in its recommendation. All it said was as early as possible, and that runs from the very first of the risk assessments, as your lordship recalls, which I think was around April or May at the latest. So that had been in existence for some months by the time that the matter was considered by the judge in August.
Well, the position we have, I think, is that the judge's judgment doesn't identify distinctly a present breach, and
No.
of either Article 2 or Article 8.
Yes.
You question whether he brought his mind to bear at all, or at least in a meaningful way, ultimately onto the contention of breach of Article 8. He made an all-encompassing declaration in mandatory terms.
Yes.
On the basis of those conclusions and lack of conclusion.
Yes.
And you submit that was satisfactory so far as Article 2 was concerned, but distinctly unsatisfactory so far as Article 8 was concerned.
Yes. We go further and say unsatisfactory. You say
Well, yeah.
wrong.
I am
But
just
of course,
looking at Miss Dennis's witness statements, which is at 12, and I couldn't find the plan, and maybe it's not for us to do, but does she link the measures that have been taken, and in particular, the new updated landfill gas risk assessment and the plan to the levels relevant to the WHO? Because the criticism the judge made of the one PBB was there's no cross-reference. And nobody seems to be telling us whether or not there's a cross-reference to the other one in any of the documents, or whether the other ones are intended at least to achieve the WHO.
no, there isn't, my lord. No.
There isn't. Do you know where in the bundle the land plan is? The one that...
Yes, if you just bear with me one moment. I think it's in the supplementary bundle. The one that's been produced in October, did you look?
No, the one that was
sorry.
produced for the 30th of July or the 31st of July.
I'm not sure we have that in the paper.
No, I don't think we have. And don't worry about it for the moment then. I mean, but you say the judge just hasn't done the exercise of looking at the documents, looking at the plan, and seeing whether or not what's proposed will meet the WHO guidelines.
And that's particularly worrying in the present case, because your lordship will recall that the finding that the judge made was that it was the current levels of pollution that were threatening my client's life expectancy. So it wasn't it was something that required urgent attention. There was no reason. What the judge has effectively done, of course, is to is to make the requirement to get below 5 parts per billion as soon as possible, and in any event before the 1st of January, because logically it seems inconceivable that if they're not
You
going
get
below
down to
5,
1
they're
without
not
also
gonna
getting
get
below
to
5,
1
yeah.
million. Whether there is a possibility of that not being the case, I'm not sure, but it would, that would seem
But logically, yeah.
that would seem to logically be the case. And the judge appears to think, well, he's trying to be practical here, and he said, oh, well, do it as soon as you can. But that doesn't address the prior question, whether the failure to have done anything about it, in the light of those first 3, at least the first 3 PHE reports, was a breach of the operational duty. And then, of course, if we're in Article 8 territory, we require justification. Why haven't they done it? They've committed to doing it. We know that there's an interference. The EA have accepted that there's interference. That interference has to be justified, as we all know. And it's impossible to divine any justification from this, from the evidence.
But is the judge's approach, in fact, in section Big Roman 8 of the judgment, to analyse Article 8 and Article 2 operational duties in the same way?
That appears to be the case, my lady.
So his reasoning just seems to be addressed to both, doesn't it?
Well, he's certainly taking the two together, but we say that he's wrong to do that because there's different considerations with respect to the World Health Organization half-hour limits.
Yeah. Okay. So it's not that he ignores Article 8, he just... You say he considers it in the wrong way.
Well, he obviously doesn't because it's in the Declaration itself.
No, exactly. No, I know, but I mean, I'm just trying to understand what your submission is. So, so you accept he deals with Article 8, but you just say he deals with it in the wrong way.
Yeah.
Right. Thank you.
It's a straightforward point.
Yeah.
But nevertheless, we would submit a very important one.
Well, he deals with Article 8, in which case, just this may seem technical, but it will become important when we are thinking about all this.
Yes.
If he does deal with Article 8, but you say in the wrong way, then it would not be necessary, would it, for us to reconstitute ourselves as a divisional court to deal with that, as it were, on a blank sheet of paper? Or would it?
Most convenient way, we would say, my lord.
Well, yes.
If you
But what is the right way? Is it straightforwardly within the compass of your cross appeal? In which case we deal with it as the Court of Appeal. I don't think this is merely technical. I think this could be quite important.
Can I think
my lady has identified, with your help, the fact that the judge purports to deal with both Article 2 and Article 8 together in that part of the judgment. Certainly there are references to both Article 2 and Article 8 in paragraphs 58 and following. If then the judge did grapple with Article 8, but you say wrongly, then that's within the scope of your cross appeal, isn't it?
Yes, it is. But one has to recall that the judge is dealing with Article 2 and Article 8 compendiously because the analysis is very similar, in fact. The Article 8 duty isn't, the Article 2 duty isn't diluted, as I think the judge says at some point. The Article 8 duty is enhanced and brought up to the protections of Article 2 when the risk to life, I think, is the gist of what the judge is saying. So he's dealing with Article 2 and Article 8 compendiously in that sense in Section 8 of the judgment. But what he's not dealing with is the point that we're particularly concerned with, and that's the World Health Organization half-hour emission limits.
So in other words, he's considered Article 8, but you say deficiently.
Yes. Well, that's one way of putting it.
Yeah.
The court has the point in the moment. So simply we say, quite put simply, we say that as an error of law, and the judge should have made that declaration. Whether to return to my Lord's point about the mechanics of that, the initial submission, the submission is that this court is competent to find an error of law and also declare that there was a breach of Article 8 at the time of the judgment in August. Our understanding of the rules is that it's a matter of the court's discretion as to whether it does that or reconstitutes itself or sends it or remits it back to the Hannah Court.
All right.
We've elided the two issues, the appeal and cross appeal. That's almost by necessity because they're both intimately linked to the same factual background. Can I just take you, the court to one other important passage that we say insists on our cross appeal, and that we get from paragraph 60. It's over the page, paragraph 48 of the report. I don't think that the court's looked at this passage yet. So looking it up at the top line, likewise, to fail to adopt the clear advice and recommendations of Public Health England, referable to protective and precautionary.
Not with you.
Sorry, it's page 48 of the report.
Oh, not paragraph 40, page 40.
No, it's paragraph 60.
Yeah, got it, yeah.
Does yours have me?
Yeah, so
start
sorry.
and implement.
I've got it now, marked it actually, yeah.
Yeah. To fail to adopt the clear advice and recommendations of Public Health England, referable to protective and precautionary health-based standards identified as appropriate by Public Health England, would be to fail to comply with positive operational duty. Only recognition, acceptance and implementation of PHE's advice through the design of effective measures to achieve the outcomes of PHE's advice could satisfy the positive operational duty given the real anxious and evidence health concerns relating to Matthew, a vulnerable child. Now, that is, we say, impeccable. Absolutely correct. The judge puts the legal obligation very clearly there. But when we relate that to the 5 parts per billion World Health Organization recommendations, we see that it necessarily flows from what he says there at the foot of paragraph 60, that there was a breach of Article 8.
Well, he's careful to put this in the conditional tense, isn't he? Would be to fail and could satisfy. So, should
well,
we not
he also uses the word only, my lord, at the beginning of that last sentence.
Oh, yes, but
only.
Yes,
that could satisfy the positive operation.
I don't ignore that. But your submission just now was that language is evidence of a finding of breach.
No. It isn't. No, that's not the submission.
No,
my lord. No, we say that the judge there encapsulates what the legal position is. In general terms.
So
if
it would be a breach if they failed to do that.
Yeah.
All right.
It necessarily follows from that analysis that there was a breach.
Yes, if they didn't comply with those principles or that approach, they would be committing a breach.
Yes. I mean, put shortly, he says that what's required is through the design of effective measures to achieve the outcomes in PHE's advice. Well, they simply haven't done it. No evidence that they've done it. And as we say, there's no justification for not having done it either.
Yeah. Well, that's an argument you've made.
Yeah. Just bear with me one moment. reporting Laing. No further matters, my Lord.
Thank you very much,
Unless
Mr.
there's any
Wise.
questions from the court.
Thank you very much, Mr. Wise. Yes, Mr. Hart.
As I said yesterday, I would indeed be short because my cases, both on appeal and cross appeal, was made very convincingly by Mr. Mould, both in writing and also in his submissions to the court,
Are you adopting those submissions?
which I adopt.
Yep.
So I adopt both his skeletons and also his oral submissions made to you, which means that I can then deal with things very much at a headline level and just pick up one detailed point about another problem with the declaration in the form that we have it. Our submission is that there should be no declaration. The first point is that the agency was not in breach in the way that they regulated the site as matters evolved during 2021. There was no evidence adduced that the agency should have required the interested party to do anything more than to respond to the iterative processes of improvements in gas management and site capping which occurred during 2021. This comes from the fact that the problem was a deep-seated one. It resulted from waste already deposited on site. It was not a problem of fresh waste inputs causing the difficulties. Our second point is that the judge's reason in law for granting a declaration appear to come from a misapplication of Fadayeva. And the court will have this point, paragraph 133, to the completely different set of facts facing the judge. The third is, given the agency's position in respect of the PHE guidance, no declaration was justified. Put it very shortly, but I hope that encapsulates our submissions both on appeal and cross appeal. I said I would mention something about the defects in the declaration, as we would say it, and many of those have been identified so far in the course of submissions. The first and overwhelming problem is that the declaration terms a reasonable steps obligation to be found in the human rights case law into an achievement of result. And we've heard the words will and do effectively achieve on many occasions. My Lord Justice Lewis mentioned in the practical context the instance of COVID shutting the site or disabling the site in some way. We had in mind another day-to-day example. What happens if the flare goes down on site? The flare obviously is the way of getting rid of excess gas, which cannot be put through the gas engines and go into thereby energy go into the grid. Let's just assume for a moment that it's no fault of the interested party if the flare went down, let alone the fault of the agency. It takes a few days to come back into service, and there are consequent spikes in off-site H2S for a few days. That would put the agency in breach of the declaration as drafted. So that's the practical level.
When you speak of the flare going down, what might cause that to happen?
It might be an engineering problem, all manners of mechanical or electrical failures.
What happens? I mean, flaring is the burning of the gas.
That's it.
And the mechanism for doing that, I don't know exactly how it works, but it has presumably valves in it on other moving parts that admit a flow of gas for combustion.
From all the wells on the site.
Yeah, and if there's an interruption in the flow of gas, for whatever reason, be it mechanical or some other obstruction to the movement of gas, the flame will go out.
Yes.
And would need to be reignited.
And or something repaired.
Yes, reignited together with any repair to ensure the free flow of gas to the point of combustion.
Sometimes you can do that in the day, sometimes you can't. Yeah. And remember, we're on a daily.
How many flares are there actually on the site?
There are, forgive me,
a broad number will do, I'm sure.
Three from recollection, but I will be corrected if I'm wrong as to that. There is in fact discussion at the moment about replacing one flare with a larger one. But I'm just simply giving it as a hypothetical example of something which could go wrong. Yeah. Maybe some circumstances due to the interested party. It may in other circumstances be nothing, not my fault at all. But it's pretty unlikely to see that it would be, quotes, the fault of the agency, and yet the agency would be in breach of the limits for the days for which there was excess gas off-site.
And that's inevitable, is it, from the declaration? Because what they must do is implement the advice, and that you would say is the absolute, because it's a daily level of 1 part per billion or whatever. But they do that by designing and applying such measures as will effectively achieve. So if they've got the measures designed and applied, but they break down on a particular day, that's not all right, is it? In this
well, that seems to be the way in which the declaration is drafted.
Effectively achieve doesn't mean on the whole most days. It means achieve.
That's right.
It means have the effect of achieving the reduction below.
Because it is then tied into
the levels.
To its daily concentrations.
Yes, I mean, I read effectively in the context as meaning in an effective way.
Yes.
Not, as
have
it
a
were,
go.
Give or take.
Yeah.
Yes.
Yeah.
Most days, or whatever one wants to qualify the word achieve. The verb achieve is rendered the more imperative by the addition of the adverb effectively.
Yes.
And a will and do.
Yeah. So will and do effectively.
And will and do. Yes.
Yeah.
So that's the practicality problem with the declaration. The second point the court is well aware of, which is it doesn't allow for any change in the standards adopted by PHE. And as the court is well aware, there was actually a change in the standards between PHE 3 and PHE 4, because in PHE 3, you may recall that there were 2 potential long-term standards being mentioned. One was the US EPA, and the other one, which was 7, was effectively the Californian standard. And those were both put in PHE 3, and the Californian one deleted from PH4.
That was a move to a more strict one, from 7 to 1.
Yes.
There's nothing to say there wouldn't be an even more strict movement downwards, from 1 to less than 1, as well as going
or
upwards.
1 to 7.
Yes, it could go either way.
Yes.
So this declaration means that even if PhD come back and say, in fact, we've underestimated it, we've got more research now about children and hydrogen gas, and it's worse than we thought, agency will say, well, don't worry, we've complied with our legal obligations. But then I suppose Mr Wise would have to come back and get a new case to say, no, it's worse than we thought for children. We've now filled the information gap.
But if it goes the other way, then one's got to come back to court to sort that out.
Yeah. But your point is you can't have absolute standards shift in scientific world.
Yeah. That's what regulators are for, and those to whom regulators go. The detailed point I wanted to make is another problem we say with the declaration, which is the fact that in respect of the long-term US EPA, it fastens on daily concentrations. So you take the average readings for a particular day. This is what the declaration appears to contemplate. And if it's over the US EPA breach, if it's over the 1 ppb, there is breach. And it occurs to us that ties the agency's hands, and indeed the PHE's hands, as to the relevant averaging period for what is, of course, a long-term standard. And we say that the one-day provision in the declaration is at least questionable, given the content of the 4th PHE report. Can I just, I know we know it well, but can I just invite your court to go to that, please, at tab 25, supplemental 1. And to page 444, please. 444 is the table 2 is the familiar setting out of the standards. We can see the 4 standards set out there.
It's tab 26, isn't it?
Sorry, tab
26.
26. Forgive me.
Yeah, that's all right. It's page 444 anyway.
Page 444. And we've seen this in the past, but the ATSDR intermediate up to a year is 30 milligrams, 20 ppb, and then, as we know, the US EPA is 2 milligrams per meter cubed, 1 ppb. But if one goes over the page to see how, to 446, forgive me, to see how it was, the SDR was applied in this case. So this is under the heading hydrogen sulphide medium-term exposure. To assess medium-term exposure to hydrogen sulphide during 2021, the calculated average of the daily exposure concentrations for the March to June data has been compared with the ATSR intermediate MLR of 30 milligrams per cubic meter, which applies cumulatively up to a year. And then the court will see.
I'm not sure I've understood that. So what have they done? They've taken 3 months' data and multiplied it by 4.
No, they've taken all the data for the 3 months,
Yeah.
3 months or so that there has been monitoring,
Yeah.
and say during those 3 months or so, what is the average?
Oh, I see. Okay, right.
Yeah.
And that's a calculated daily average.
Calculated daily average built into
Yeah.
into that longer period.
Yes, but the unit of time is a day.
That's it. Yes. And hence, comparing those concentrations as they remark, the average daily concentrations over that period are below the ATSDR.
So what's your point? I now understand what you've just shown me.
Yes.
What I don't understand is what its relevance is.
Its relevance is over what period do you average?
Yeah.
You average just over a day. So there's a breach at the end of one day. Or you average over a longer period. So you might have one blip.
You might have one really bad day, but 6 trivial emissions day, and overall, if you add them all up and divide it by 7, it would be very different from adding that up on one day.
Precisely.
Yeah.
Well,
Okay.
it's the difference in principle between the unit of time being 24 hours on the one hand, and on the other hand, the unit of time being a 3-month period.
Yeah.
Exactly. Exactly. And we don't see the PHE doing this specifically for our US EPA in 2021, but we do see how they did it for the earlier periods. If the court moves your eye down to the last 6 or 7 lines of that page, assessment of previous monitoring data for hydrogen sulphide.
I was wrong. I said 3 months. I should have said 4 months, because it's March, April, May, June in this example.
Yes.
I mean, the
yes.
point's the same, but
Yes.
I was mistaken in saying 3 months rather than 4.
So let me get this straight. This one that you've shown us in 446 is for the medium term exposure,
That's right.
the ATSDRL or whatever it's
That's
called.
it.
And they've done it by the 4-month calculated average for that. They haven't done it, you say, for the PHE, for the EPA.
But I suggest we can see how they would do it for
What they did in the earlier years.
exactly.
And how do we know what they did then in the earlier years?
We can see that in the last few lines to assess long-term exposure. The previous monitoring data for those 5 or 6 months in 17 to 18 and the 5 months in 19 being compared against the US EPA.
Right. So in a nutshell, if I understood it, your point is the direct declaration says do it each day on a day.
Yep.
Whereas the PHE advice appears to be prepared to average over at least a 4 or 5 month period.
However long a period. And then just completing the point, turning over the page, 447. See the result of that exercise. For the 2017-18 monitoring period, the average 24-hour concentration was 0.85. 2019, 0.95. These
But we don't know
concentrations
if there
were
was
below.
one. Yes, we don't know whether there was one day when it was 6, and then 6 days when it was 0.
Exactly.
Okay.
That's
Right. So you're saying the judge has misunderstood the document?
yes. It doesn't seem as if there was any argument about it.
Did you mention it at the time?
No.
When you had all the arguments about what daily meant, it didn't resurface then?
No.
But you say the problem is getting a declaration after a 3-day court hearing as opposed to the regulators mulling all this over for weeks to work out what the proper way of going forward is. That you say is the vice.
Yes. I mean, again, I repeat the point. It's ultimately a matter for the agency in consultation with PHE to come up with whatever averaging approach they intend to take. My point is that it appears on any view to be not to be one day.
Yes, there are 2 points. One is it's not the business of the court to be doing this. Secondly, when the court does it and gets it wrong, that demonstrates one of the reasons why the court should not be doing it.
Yes, exactly. Exactly. In the course of our skeleton, which is tab 9, we made an egregious error about the ATSDR, and perhaps I can just correct that. Paragraph 13 of tab 9. last 5 lines.
Which paragraph? Sorry, I've taken it out of where you said it's now got in a different place. So which paragraph, please?
It's paragraph 13.
13, right, yeah.
It's a sentence, 4 lines from starting, in addition. In addition, the results data from the end to the end of June shows that the levels exceeded the ACCR. Well, they didn't.
No, they were
just
below.
Just as I've indicated.
So we should delete exceeded and...
Delete those 2 lines, yes.
Or just delete them?
Yes. Because in fact, as the court will recall, there were 2 recommendations. One was made about the Wahoo 5-part pavilion, and the second was made about the USAPL.
We've made that deletion.
Lords, I was going to leave over any comments on Mr. Mould's declaration of this morning until I've heard him on that, if I may do it in that form, because Mr. Wise has made some various observations on that. But subject to that point, those are my submissions, unless I can help you any further.
Thank you very much, Mr. Hart. Mr. Mould.
Yeah.
You're now responding to the
Thank you.
cross appeal and replying on the appeal.
In a sense, it breaks down into the 2 articles, because the way things have developed, as I understand it, the response to the agency's appeal focuses on Article 2, and the cross appeal is focused upon the judge's alleged errors in relation to the Article 8 aspect of the claim.
Well, I think, having listened to Mr. Wise, there's a number of things. His grounds actually say that there were findings, and the judge should have followed that through and made declarations accordingly, applying the approach in hand. But he says if the judge was wrong about that, findings should be made. And today, in oral submissions, we were in a position to make findings about Article 2 because the judge made all the relevant findings of fact. And I raised it maybe a red herring that were we in the position to take the same view as Article 8, but my ladies pointed out that, in fact, the judge saw them both together, so presumably he didn't see any difference.
Yes. So far as Article 2 is concerned, Mr. Wise has been quite clear that his case is founded upon an alleged breach, as he sees it, a clear breach, based on Dr. Sinha's report. And the way he put it was, the current levels of hydrogen sulphide, as reported in the Public Health England reports, constitute a breach of Article 2 and indeed Article 8 insofar as Matthew is concerned. That was the case that the judge recorded him as having made in the judgment. If I can just ask you to turn, please, to paragraph 45, at the end of paragraph 45 on page 118 of your bundle. He records Mr. Wise's case. This is in relation to Article 2, paragraph 45. You see the final 2 sentences on page 36. It's inappropriate or unnecessary for the court to identify any particular step or steps which the Environment Agency should be requiring the interested party to take. What is appropriate and sufficient is for the court to find that the current levels of hydrogen sulphide from the quarry constitute a breach by the Environment Agency of its positive operational duty under Article 2. So, excessive levels, ergo breach.
I think if anything, Mr. Wise says at least Well, he says at the earliest, the 4th of the 7th of 21, because that's what Dr. Sinner says.
Yes.
But he says certainly by the date of the hearing. The grounds of appeal at page 51 in the core bundle. If you look at paragraph 2, ground 1, the judge made clear findings that the Environment Agency had not complied with its obligations under Article 2 and 8 at the time of the hearing. And he's saying the judge should have gone on and said, given those clear findings. So I think Mr. Wise, on the grounds of appeal, is saying that there was a finding on the 18th of August that there was a breach as well. So if it wasn't the 4th of July, it was the 18th of August.
Yes. Well, I'll come to the question as to what the judge found in relation to that in a moment. But that's the case that the focus of this introductory submission is that the judge identified Mr. Wise's case as being fundamentally founded upon the fact of current levels of hydrogen sulphide from the quarry. And he makes and he records him as having made essentially the same submission in relation to Article 8, paragraph 46, at the very bottom of the page. The Article 8 obligation is being breached and no fair balance has been struck, essentially for the same reasons as seen in relation to Article 2, but also as having regard to the experience of the local community. Now, the core submission that I made yesterday, by reference to the European case law, both in relation to Article 2 and Article 8, was this. In cases involving hazardous or dangerous industrial activities, the fact of harm, in this case excessive levels of polluting gas in the atmosphere, raises the case for a violation. But it does not of itself make good that there has been a violation.
It's a necessary but not sufficient condition.
Exactly. Gets you through the door, if you will. Now, the judge correctly approached the matter in that way under the heading, are the positive operational duties triggered, in paragraphs 55 to 57 of his judgment. In relation to Article 2, he deals with that in paragraphs 55 and 56, and in relation to Article 8, he deals with it in 57. And I invite this court to read paragraph 56 in particular, because it is in that paragraph that the judge brings the evidence he had heard from Dr. Sinha about Matthew's pre-existing chronic respiratory condition and the implications for his long-term recovery from that condition and avoiding the onset of COPD within the Article 8, within the Article 2 analysis. Can I just ask you to read paragraph 56?
Yeah. Yes.
The sentence which ties those findings of fact into the Article 2 principled approach that we saw yesterday in Fadieva, applied in the domestic context by the Supreme Court in Rabone, is the sentence after the number 4, about 5 lines up from the bottom of, from the end of paragraph 56. What this means on the evidence. BPD is properly to be seen as constituting an inevitable precursor to a serious illness, reducing life expectancy, where that very inevitability is attributable to the ongoing exposure to hydrogen sulphide emissions from the quarry at current levels, against which the agency has the power to protect. And so, put in Budayeva terms, we have facts here that bring into play the agency's positive obligation to safeguard life. And therefore, the two-stage analysis is itself also engaged. Has the framework duty been fulfilled? And has the operational duty to take practical measures been fulfilled? You recall those 2 stages. The framework duty had been fulfilled. That was not an issue. I'll give you the reference for that. Paragraph 44 of the judgment. Mr. Mould submits that the framework duty is important, and in the present case, insofar as it is triggered, it has clearly been discharged. I accept both of those submissions, which were not contested by Mr. Mould. The issue was whether the operational duty had been or was being fulfilled, given that this was at least arguably a case where the agency had not yet completed the work that it had started to take in order to fulfill its positive obligation. And you'll recall that the principles which apply to the court's analysis of whether the operational duty had been fulfilled are those set out in paragraphs 134 and 135 of Budayeva. The choice of practical measures in fulfillment of the operational duty is for the regulator. There is a margin of appreciation, and the court is astute to issues of whether things that it said that the regulator ought to have done or be doing are in proportion to the problem that it is seeking to serve, or excessively burdensome. But may I suggest that an obvious question that the court will be astute to also in the practical application of those principles is, who is best placed to judge whether any particular measure will or will not be effective in practice to remediate the problem which gives rise to the positive obligation, in this case, the excessive levels of poisonous gas. And the answer on the authority of domestic case law is clear. It is the regulator who is best placed to make that judgment. And so where the 2016 regulations give a panoply of powers to the Environment Agency as the environmental regulator, which are at its disposal for the purposes of licensing, regulating, and controlling the operation of the dangerous industrial activities involved in a landfill operation, it is for the agency to judge which of those powers it should invoke in order effectively to address the problem which has given rise to its positive obligations under Article 2 and the operation and in the discharge of its operational duty. And that is what Miss Dennis says the agency has done in this case. She explains that the agency considered the scope of the enforcement notice that it served earlier in 2021. It considered the deployment of the power of suspension in order to prevent further wastes being imported into the site. It considered whether it should issue a revocation in relation to the permit. And she explains why the agency's judgment was that none of those measures would add effectively to the remediation of the problem. She explains that the measures for the control and management and suppression of landfill gas emissions that the agency has required and continued at the date of the hearing to require of the operator under what she characterises as the bespoke compliance action plan, which I'll show you a little later. Those measures were the effective measures in practice that were best placed to resolve and remedy the problem. And she has the support of Mr. Browell, who is the agency's expert in relation to that technical issue. I showed you his evidence yesterday. And so the question is there any is there anything in the evidence before this court upon which this court could quarrel or make a different finding? I should say not this court. Was there anything in the evidence before Mr. Justice Fordham, is the best way, that's the right way to put it, upon which he could make a finding, as Mr. Wise put it, of breach in relation to positive operational duty under Article 2? In order to do so, Mr. Justice Fordham would have had to have held that, that in the face of the agency's evidence, it was nevertheless not deploying its powers in the way that it should, viewing the matter reasonably. I accept the objective approach. Mr. Justice Fordham was entitled to ask himself that question. But I say that not only did he not make an adverse finding to the agency as to what they had been doing in that respect, but also that it would have not have been open to him.
But I think what he really says is what we really need and what's missing from the domestic legislative framework is the standards, the emission levels. You've accepted PHE. Those are to be equated to the relevant applicable domestic levels for controlling pollution. So once you've tied yourself to that mast, you need to show you've got measures to achieve that.
I'm on what had happened up until
PHE, okay.
And I'm on the point. I say that it's relevant. It was relevant for the judge, and it's relevant for this court.
Yeah.
To focus on the necessary prerequisite to a finding of violation, notwithstanding that the positive obligation has arisen by virtue of the excessive levels of gas. That's the critical question. The burden is on the agency to establish that it took practical measures. I'm saying the evidence unequivocally shows that it did, and it would continue to do so. Now, what then happens is that, well, let's not jump ahead. Is there any evidence to support the contrary argument, not by reference to the measures themselves and the agency's judgment, but by reference to the advice that it was receiving from Public Health England before the strong recommendation about the long term first came into the equation on the 5th of August 2021? For that purpose, and the answer is the agency's position was endorsed in terms, let's say the Environment Agency's position was endorsed in terms as being the appropriate approach to take, applying what Dr. Coetzee describes as the suitable measure to address the problem that had arisen in early 2021. And that is borne out in successive editions of the Public Health England risk assessments. Can we turn to those documents? It's in the supplementary bundle. Firstly, Dr. Coetzee's evidence, which is at tab 22, beginning at page 391. The relevant forgive me. It's paragraph paragraph 11 on page 394. I'll pass over, for the purpose of this mission, the first two sentences, because they're dealing with the odour value. The fourth line, in the fifth line, we have this. The ATSDR intermediate value of 30 micrograms per cubic meters, 20 parts per billion, is the suitable value to assess the exposure to hydrogen sulphide throughout 2021, and that is the evidence of Dr. Coetzee. And so we turn then to the risk assessment report to see the performance of the site insofar as hydrogen sulphide emission is concerned, measured against that suitable value. Firstly, NC1, beginning at page 411, and the relevant analysis is at 415.
For NC1, is it 397 in my bundle?
Oh, I'm so sorry, you're absolutely right. I was on NC2. Forgive me. It's at 397. Yeah, it begins at 397. The relevant assessment is at 402 under the heading intermediate exposure. To assess intermediate exposure to hydrogen sulphide during 2021, the calculated average daily exposure concentrations from the March 2021 data have been compared against the Agency for Toxic Substances and Disease Registry intermediate minimal risk level, 50 micrograms per cubic meter, which applies up to a year. The average daily hydrogen sulphide concentrations of 5.75 and 27.73 micrograms per cubic meter for MFF2 and 9 respectively from the 5th to the 31st of March 2021 are below that level. As such, any risk to long-term physical health is likely to be small. So, analysing the results of air quality monitoring from the then current 2 monitoring stations for that period showed that the suitable level was being achieved. We then turn to NC2, which is the one that begins at 411. The corresponding assessment is at page 415. Under the heading, again, intermediate exposure. To assess intermediate exposure to hydrogen sulphide during 2021, the calculated average of the daily exposure concentrations from the March and April data have been compared to the 30 micrograms per cubic metre level, and we see the average daily hydrogen sulphide concentrations now, of course, for the 4 monitoring stations that address all points of the compass, including that which was closest to Matthew's home, MF1, and we see that in each case, as the report says, at all the monitoring stations, the average daily hydrogen sulphide concentrations are below the intermediate level. Again, as such, any risk to the long-term physical health is likely to be small. NC3, bringing us up to the end of May, beginning at 426. The relevant report is at 431 at the top of the page, medium-term exposure. I won't read out again, but you'll see that, again, the same assessment. At all the monitoring stations, the average daily hydrogen sulphide concentrations are below the intermediate level. As such, any risk to long-term physical health is likely to be small.
Sorry, you're reading from
431.
431.
Top of the page, medium-term exposure. And I read out, instead of reading laboriously through the same verbiage, I've read out the conclusion under the tabulated results from each of the monitoring stations. And if one wants to see the point reinforced in the conclusions at page 433, the fourth paragraph, the current hydrogen sulphide data up to the end of May shows continuing exposure to the population around the site above levels acceptable for long-term exposure. The ATSDR intermediate MRL for exposure between 14 to 364 days has not been exceeded. And then bringing us up to date with the with NC4 hot off the press at the time of the hearing, beginning at page 441. You know, it's data up to the end of June. The relevant page is page 446. Under the heading Hydrogen Sulphide Medium-Term Exposure. To assess medium-term exposure to hydrogen sulphide during 2021, the calculated average of the daily exposure concentrations from March to June data has been compared against the agency's intermediate MRL, 30 micrograms per cubic metre, which applies cumulatively up to 1 year. Then the average daily concentrations are set out. At all the monitoring stations, the average daily hydrogen sulphide concentrations over the period March to June are below that level. This means that concentrations experienced so far in 2021 are unlikely to cause a lasting impact to physical health, and as such, any risk to long-term lifetime physical health is likely to be small. And again, that is picked up in the conclusions in the fourth paragraph on page 449. Now, the judge, if we just turn away from NC4, go back to the judgment, the judge addressed the significance of those assessments of the performance of the site against that intermediate level yardstick, on page 104 in subparagraph 6, page 32, judgment, paragraph 32, subparagraph 6, it's the passage at the top of page 104 of the court binding. PHE has assessed the intermediate value for days 15 to 364, for periods up to 1 year, is appropriate when assessing longer-term implications of concentrations experienced so far in 2021. PHE states in its conclusions that it is to compare the concentrations to that intermediate value in order to assess the risk from increased concentrations in 2021. In order to understand this, I raised with all counsel this question. What was it that made 2021 year 1 up to day 364 so far as hydrogen sulphide emissions from the quarry are concerned? The mould QC supplied what, in my judgment, was a convincing answer. He pointed to PHE's assessment that 2017-2019 emissions were below the US EPA reference concentration of 1 part per billion. Mr. Hart showed you that passage. He submitted, in essence, that having found compliance with this guideline in years prior to 2021, PHE was justifiably treating the increased emissions experienced so far in 2021 as being a new problem to which the intermediate value was applicable. I accept that explanation of PHE's written analysis. It is coherent and logical. It joins the dots between features within PHE's reasoned documented assessment. It does mean that an assessment favourable to the quarry has been adopted by PHE in relation to the year 2020 when there was no MMF monitoring and when levels are not assessed in the document. It also means that the 1-year explanation and application of the intermediate value would apply only to emissions during 2021. The intermediate value being days 15 to 364 would not be applicable from January 2022. Mr. Mould accepted this was the logic of his explanation, and I agree with him. But what it does mean is that what Mr. Wise could not look to the cumulative Public Health England risk assessments to provide him with clear evidence in support of a present health-based risk to justify the conclusion, not only that the levels were higher than they should be, but that those levels led inexorably to a finding of violation of Matthew's Article 2 rights at the date this claim was made, on the basis of Dr. Sinha's evidence, and indeed at the date of the hearing. Because the assessment of Public Health England was consistent all the way through from NC1 to NC4, that latter being the current assessment at the date when Mr. Justice Fordham considers the matter. So one can well understand why, firstly, having regard to the agency's evidence as to the steps it had taken, what it judged to be effective and not, see Dennis and Rowell, the agency's decision to introduce a bespoke air quality monitoring strategy before monitoring stations, see Mr. Lowe, and the evidence of the Public Health England witness, Dr. Kirksey, and most specifically the risk assessments themselves carried out by Public Health England. All those matters pointed consistently to a finding that there was no current breach.
And isn't that what 32.8 says? You take us to 32.6, which is the days, but 32.8 is the actual finding that says it hasn't been exceeded so far for 2021.
Yeah.
And then it goes on to say, but if we carry on that level, there is going to be a problem. But that's a different issue.
That's the point.
Yeah.
That's
your point.
My Lord is absolutely right. I'm grateful for that reference. That's the point. And so, on a fair reading of this judgment, in the light of the evidence that was before the court, particularly in relation to levels, health-related level, acceptable level. Paragraph 64 and paragraph 68 must be read as a judge clearly and rightly declining to find a current breach in relation to Article 2. What the judge was concerned with in paragraphs 63 and 64, sorry, 62, 63 and 64, was concerned with the implications of NC4 and the second of those strong recommendations that came in for the first time in relation to the long-term position. And the judge's position was, I don't have a clearly stated and evidenced position from the agency what, if anything, it proposes to do in reaction to that new recommendation. Looking forward not to the end of 2021, but to the position from the beginning of 2022, when the suitable yardstick for assessment of long-term health will cease to be the intermediate guideline and will become the EPA long-term guideline on Public Health England's specialist advice. And so we're back to the point. The judge was clearly looking forward. He was saying, I haven't seen the agency's stated position, see paragraph 59, and what I said in that to him in paragraph 59, that it would do what it had done hitherto, which was to take the advice of Public Health England and expect to act upon it. Not that was something that he'd been told by me, but it hadn't been dealt with in the evidence, and there wasn't a plan or a program which said this program has been updated, reviewed, revised in order to bring in different, changed, further measures with a view to achieving that long-term standard. So we're back to the issue that I made submissions about yesterday. Was, given the timing and given the terms in which the domestic legislation is put under sections 7 and 8 of the Human Rights Act, where the court's powers are to intervene where the regulatory body proposes to act or to fail to act unlawfully. Was there here any proper basis for the judge to grant relief? And I say, as you know, there was not. This is not simply a question of challenging the judge's discretion, although it goes to that, because this court can intervene if it finds that the judge exercised indiscretion in a way that is insupportable in the light of the evidence. But it goes to the legality of the judge's decision to intervene, because the basis on which he intervened was he took the view that the stated position of Public Health England in relation to that long-term recommendation should be translated from the strong recommendation of the specialist body, which was a question ultimately of fact. That should be converted into a legal obligation, a statement of the law. And my lady, if I may respectfully say so, identified where that error with respect to the judge crept into his thinking in paragraph 60. I note the time. I'll complete this submission if I may, and then.
Yes.
crept into the judge's thinking in paragraph 60 on page 129, where having accepted my fact-based assessment, my fact-based position in paragraph 59, if the EA takes actions which have as their purpose and design the implementation of Public Health England's recommendation, the response will constitute a discharge of the positive obligation arising. The judge says, not only would that be sufficient, but I think it's necessary. It's a legal requirement. There's no support for that in the authority. And it was not justified on the evidence before him. PHE did not say the only way in which you can fulfill your obligation as regulator under Article 2 here is to stick inexorably to what we have recommended. Their recommendation was to take all measures, by which they must have meant all measures that you, in your judgment, consider to be effective.
But it's still tying to a standard. Measures aren't just measures in the abstract. They've got to be tied to something.
They are
all measures to get to Doncaster, not all measures to have a car.
No, exactly. But the point is that the distinction I'm drawing here, I agree, the distinction I'm drawing here is I was advancing a proposition of fact. It may be that the agency would be extremely well advised to do what I said. Indeed, that was the force of my submission. But there's a clear distinction between that and saying they had to do what I said as a matter of law. And
or at that stage,
yeah.
at that time,
yeah.
without time to consider that they had to do it.
Yeah. I mean, in European terms, what the judge has done is to take Public Health England's strong recommendation at that time and to use it as the basis for defining the margin of appreciation in law. There's no support for that in the European case, and there's no support for it in Rabone. I appreciate I've gone on 10 minutes beyond short adjournment, but
it would be helpful to have the same analysis of Article 8, because everyone's just wrapped it up with words like triggering and positive obligation, but it's actually quite important to do the same exercise, not now, but at some stage.
I'll review my notes, but I think I have that in store for you. You can bear
I can
it.
hardly wait.
Can we just, at this point, have a look at progress? We'll come back at 2:10. How much longer do you think
Well,
you will be?
I think I've got about another 45 minutes,
Right.
but I'm going to make sure if we come back at 2:10, I'll
Yeah.
commit myself now to not going beyond 3, so that.
And just trying to get the sequence right. Mr. Wise, then you don't know exactly how long.
No, but I would imagine 20 minutes, my lord, maximum.
And
I've only just got the point on Mr. Mole's declaration.
that's right. So that
Or,
yeah,
sorry,
so
just
we're
reserving that matter, which
Yeah.
shouldn't take
we're
any
looking
time
at
at all.
broadly about an hour and a quarter. So.
Yeah.
All right, that's helpful. Thank you. We'll come back at 2:10. Thank you very much.
Compromise.